कहा उस्मान उसमें उस्मान डार ने बोला ये बात शेख रशीद ने बोली।
कैपेसिटी में क्यों नहीं आते हैं? अब आपने देखा ना इसमें अपने पेज 3 पे ख्वाजा मोहम्मद आसिफ का भी नाम लिखा हुआ आपने, PMLN स्टार, आपके अपनी उसमें जो है स्टार कैंडिडेट ख्वाजा मोहम्मद आसिफ
जी
विंड मिसिंग और PMLN के ही है। अब आपके पास अथॉरिटी है कि इतने सारे नाम आपने लिखे हैं।
मैं तो वो चीजें
उनके नाम जो एफिडेविट्स हैं कि यार शायद
उनका दैट एक्सटेंट ग्रीवेंस के वो वापस आ गए, वो रेस्ट हो गया। लेकिन जो कुछ उनके साथ हुआ उसके बारे में
आप उसके गवाह हैं शायद सर
पूरा पाकिस्तान गवाह है।
नहीं ये देखिए ये डायलॉग इधर ना करें, ये बाहर जाके आप टॉक शोज पे कर लीजिए। नहीं प्लीज, अगर आप हमारा मजाक उड़ाएंगे करके, नहीं हम आपको इजाजत नहीं देंगे। अगर आप इस मैटर को सीरियसली नहीं लेना चाहते हैं, जो हम बहुत सीरियसली लेना चाह रहे हैं इस मैटर को, और आप इसको अगर सियासी तौर पे इस्तेमाल करना चाह रहे हैं, हम इजाजत नहीं देंगे आपको
इस पे।
ठीक है, ये बात कहना, अगर आप ऐसी बातें करेंगे कि आपके ख्याल में जो पाकिस्तान पीपल्स पार्टी है, दूसरी पाकिस्तान मुस्लिम लीग है, ये आपने सारे उनके तो किसी का आपने जिक्र नहीं किया इसमें। आपने एक मखसूस पॉलिटिकल पार्टी के जब आप एक जिक्र करते हैं ना, तो फिर सवालात भी उठेंगे। देखिए अब 184 में अब आप आए हैं, मैटर ऑफ पब्लिक इम्पोर्टेंस फॉर एनफोर्समेंट ऑफ फंडामेंटल राइट्स। ठीक है, अगर आप इसको सियासी पॉइंट स्कोरिंग के लिए इस्तेमाल करेंगे, हम आपको बिल्कुल इजाजत नहीं देंगे इस बात की। आप जितने नाम लिए हैं उनकी वाबस्तगी आपने कहा वो हमारी पार्टी छोड़ गए, भाई अब इसका हमारे पास कोई सोल्यूशन नहीं है। वो अंग्रेजी में कहावत है, अब उर्दू में पता नहीं कैसे कहेंगे, if you can't stand the heat in the kitchen, you should not be in the kitchen। ठीक है, अब हर जमाने में क्या क्या गुजरा है, पाकिस्तान की तारीख हमारे सामने है। आप तो कह रहे लोग घर आ गए, असर रसूख वाले लोग हैं, इनकी कोई है ग्रीवेंस, बाय ऑल मींस ये अदालतों के दरवाजे खुले हुए हैं। ये बातें नहीं है कि आप जाके बस इसको एक अपने मकासद के लिए इस्तेमाल करें इन चीजों को। जेन्युइन बातें हैं, आपने इन सबको किया और बीच में आपने कहीं जाकर के की बात कर दी है।
save money on your utility bills and make your home more attractive and secure with new windows from Liberty Windows and Siding. We install all manner of windows, including skylights, bay windows, awnings, vinyl windows, and much more. When only the best will do, turn to Liberty Windows and Siding.
किसी शख्स को एक बार सजा मिल गई तो बात खत्म क्यों नहीं हो जाती? ये कैसे हो सकता है कि सजा के बाद कभी इंतखाबात ना लड़ सके? संगीन गद्दारी पर इलेक्शन लड़ने की इजाजत, मगर मामूली जुराइम में सजा याफ्ता इलेक्शन नहीं लड़ सकता। जस्टिस मंसूर अली शाह के रिमार्क्स। सुप्रीम कोर्ट आर्टिकल 62(1)(f) के तहत ताहियात नाअहली की तशरीह के फैसले का दोबारा जायजा ले। अटॉर्नी जनरल की सदा। तमाम एडवोकेट जनरल्स की भी अटॉर्नी जनरल की इलेक्शन एक्ट में तरमीम की हिमायत। नवाज शरीफ की ताहियात नाअहली फैसले पर नजरसानी होनी चाहिए। अटॉर्नी जनरल। इलेक्शन लड़ने के लिए जो अहलियत बयान की गई है, अगर उस जमाने में कायदे आजम भी होते तो वो भी नाअहल हो जाते। सादिक और अमीन के अल्फाज कोई मुसलमान अपने लिए बोलने का तस्वुर नहीं कर सकता। मैं कागजात नामजदगी जमा कराता हूँ और कोई ये कहे कि अच्छे किरदार के नहीं तो मैं चैलेंज नहीं करूंगा। चीफ जस्टिस का इस्तफसार। ताहियात नाअहली केस की समाअत 4 जनवरी तक मुलतवी। हम पार्लियामेंट को कानून साजी का हुक्म नहीं दे सकते। हर इदारे को अपनी हदूद में रहना होगा। हर जो शख्स ओहदे पर होता है वो दूसरे पर जिम्मेदारी डाल देता है। चीफ जस्टिस काजी फायदा के सुप्रीम कोर्ट में जबरी गुमशुदगियों और लापता अफराद केस की बराह रास्त समाअत में रिमार्क्स। हम समझते हैं कि मिसिंग पर्सन अहम मसला है। हमने सारे टेक्निकल एतराज़ात को नज़रअंदाज कर दिया। हम आगे बढ़ चुके। आप हमें वापस ले जाना चाहते हैं। कल आप ही तनकीद करेंगे कि हमने पार्लियामान को कानून साजी का हुक्म दिया। चीफ जस्टिस का पीटीआई वकील से मुकालमा। अब तक 2200 से जायद लोग मिसिंग पर्सन हैं जिनका कुछ पता नहीं। वकील के दलाइल। जबरी गुमशुदगियों से मुतालिक कमीशन तो बना है। जस्टिस मोहम्मद अली मुसर के रिमार्क्स। कौन सा कमीशन बना है? चीफ जस्टिस का वकील पीटीआई ने शेख रशीद, सदाकत अब्बासी और दीगर की गुमशुदगियों का मामला उठा दिया। क्या ये सब लोग खुद वसाइल नहीं रखते कि अदालत आ सके? आप इस मामले को सियासी बनाना चाहते हैं तो ये फॉर्म नहीं। जो शख्स धरना केस में नजरसानी ला सकता है, क्या अपना केस नहीं लगा सकता? चीफ जस्टिस सुप्रीम कोर्ट। किसी सूरत इंतखाबात का बायकॉट नहीं करेंगे। हम लड़ेंगे। 8 फरवरी को जीत सिर्फ पीटीआई की होगी। लोग हथकंडे इस्तेमाल कर रहे हैं कि इंतखाबात ताख़ीर का शिकार हों। एक पार्टी को अगर इलेक्शन से निकाला जाएगा तो जमहूरियत डीरेल और पार्लियामेंट कमजोर होगी। चेयरमैन पीटीआई बैरिस्टर गौहर की मीडिया से गुफ्तगू। लगता है कि कुछ लोग हथकंडे इस्तेमाल कर रहे हैं कि इलेक्शन ना हो। आरोप कौन होगा, इससे उम्मीदवार को क्या फर्क पड़ता है? चीफ जस्टिस सुप्रीम कोर्ट। कोहाट में आरोप की मौतली का पेशावर हाई कोर्ट का फैसला कलदम। सुप्रीम कोर्ट ने इलेक्शन कमीशन की अपील मंजूर कर ली। आप अपनी मर्जी का आरोप चाहते हैं कि आप चाहते हैं कि इलेक्शन ही ना हो, क्योंकि ना ऐसी दरख्वास्तें दायर करने वालों पर मिसाली जुर्माना आयद करें। चीफ जस्टिस के कोहाट के हल्का PK91 में रिटर्निंग अफसरान की मौतली के खिलाफ केस की समाअत में रिमार्क्स। अदालत के फैसले के बाद इलेक्शन कमीशन ने PK91 कोहाट का नजरसानी शेड्यूल जारी कर दिया। पीटीआई इंट्रा पार्टी इलेक्शन और इंतखाबी निशान बल्ले का केस। पेशावर हाई कोर्ट ने इलेक्शन कमीशन की नजरसानी दरख्वास्त पर समाअत कल तक मुलतवी कर दी। पेशावर हाई कोर्ट ने हमें सुने बगैर हुक्म इम्तना दिया। 9 जनवरी तक मुअत्तली का फैसला वापस लिया जाए। इलेक्शन कमीशन बाइख्तियार इदारा है, अपने फैसले करने का इख्तियार है। वकील इलेक्शन कमीशन के दलाइल, इस केस में हम फैसला नहीं कर सकते। 9 जनवरी को केस डिवीजन बेंच के लिए लगा है। केस में असल दरख्वास्त गुजार कहाँ है? जस्टिस रियाज खान के रिमार्क।
One of the prescribed conditionalities either of 62 or 63.
It was perhaps introduced under clause P, sub-clause P of sub-clause 1 of 63. 63(1)P, which permits prescribing additional disqualifications through an act of parliament.
Read it again. P1P क्या है?
He is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament or of a provincial assembly under any law for the time being in force.
Now, here the word time being has been used twice. It could have said he is disqualified for being elected. So time being.
Yes.
And it's been used, the word time being has been used twice in this thing. So it assumes it's not a permanent disqualification. I don't know.
That's what the first usage of for the time being actually indicates. What my lord has just observed, that perhaps it is a time-bound disqualification which can be introduced through a statute.
Okay. Now, with regard to the disqualification of did the law for degrees, the law did not provide a time period disqualification. So the Supreme Court, in the case of Samiullah Baloch, held that since no disqualification period has been prescribed, it will be forever.
So long as the declaration is in the field, the disqualification stays.
And the to be resolved now, if the judgment of the Supreme Court also stands and the law also stands, that till the law came into effect, that may have been the position, but since the law has now occupied the field of legislation and prescribed a particular period of time, unless we hear a challenge to the law, which there is no challenge to the law, then why should we disregard the law? That's one way of looking at it. And we don't need to touch the judgment at all, because at that time, this aspect of the matter had not been legislated upon either in the Constitution or by law. So then the courts kind of filled in the vacuum and said that it should be lifetime because there is no period of disqualification. So Samiullah Baloch judgment stays intact, but the law has come in place and intact, but the substantive clause, that's one reading of it. What do you have to say to that?
The question would be, can the sub-constitutional legislation control the Constitution?
So that is one, and then the second would be, can there be legislative overruling of a judgment without first removing the basis on which the judgment came up? So
can we go to the judgment now of the Supreme Court?
My lord,
relevant provisions, whatever you think are relevant for our reading.
Paragraphs, my lord.
Paragraph 35 है
जी 35 and 445
page पे
जी. So this is PLD 2018 Supreme Court 405.
ये 4 जजमेंट जो पहले है ना, उनका रेफरेंस है पहले इसके अंदर ना, 4 जजमेंट हैं, उसके साथ फिर समीउल्लाह है जी. एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलाडीनो
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
Mr. Attorney General, to nullify Samila Baloch, the amendment would have been in the Constitution.
My lord, that's why I
mean, if you're looking at the basis of the judgment,
Yeah.
the basis of the judgment emanates from the Constitution. So unless the Constitution were to be amended, Samila Baloch could not be undone.
So, because Samiullah Baloch is interpreting a constitutional provision, and Samiullah Baloch basically holds that the declaration which is referred to in 62(1)(f has to remain in field till such, because through clauses A through G. Now, as far as D, E, F are concerned, they are all without any timeline. Now, the question before your lordship, and it was also argued in Samiullah Baloch. In fact, all the councils before Samiullah Baloch.
If we consider that through Samiullah Baloch the Constitution has been amended, then the constitutional amendment is required, as per my understanding.
My lord,
His interpretation.
My lord, with respect, Samiullah Baloch also read something into the Constitution which was not provided, and
Like, what did they read into?
my lord, while comparing now, while examining 62(1)(f, the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h, which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that, because there is a personal cost price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases,
I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry, that carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and test election. But if you just forget to write something in the form, you would be out forever. So how does one reconcile? It's a matter of interpretation.
Yes, so that is what my respectful submission would be, because in both, in G, H, and also in I, there is an adverse finding against the person, a declaration by a court of law against that person. In those proceedings, those declarations, of course, subsist. He serves the time or whatever punishment provided by law, and then he can come back in after 5 years. Now, here, while looking at 62(1)(f, where there is this, the standard of proof is lower compared to those criminal proceedings under 63(1)(h, which is beyond any shadow of doubt, and that declaration has still come out beyond any shadow of doubt. And here is preponderance of evidence of somewhere between the two, and here the person is out forever.
But before we go into that, could you just explain to us how can any court, a civil court, grant declaration which is in the negative? I mean, how can a court grant a declaration that you're not sagacious? That cannot happen. So how does that work? I mean, I've been always perplexed about this. We can't get a negative declaration from any court. Can a court say that you're not sagacious? Why would that happen? Because no civil proceedings could lead to a negative declaration. It's always positive. So I don't understand how a court will ever give such a declaration. So then most of the courts which have given this declaration are the constitutional courts. So you have
That's another question
case, and in those cases, is the declaration absolutely clear? I mean, does it say that you're not sagacious, or then we infer from the judgment that because you presented a fake degree, as a consequence, we understand that you are not a mean? I mean, let me just go to the language of 62(1)(f to understand what do we mean by
cannot record evidence, where witnesses cannot be cross-examined. A person against whom an allegation has been brought cannot really defend himself as he is able to in a trial. Would the declaration coming from Constitutional Court suffice for 62(1)?
What is the question which has been there?
You show your vulnerability and they will latch on.
First of all, can there be a civil court granting a
First
negative
case,
declaration? Number one.
both
And
the
number
boys
two, the
were
question is
manically
that
acting
in
demonically,
the
persons were
constitutional
actually brothers.
proceedings,
He had an
where
extramarital
there is
affair
no
with
evidence being
wife.
taken,
When this
the court
person
has
is
the
trying
right
to
to
stab
decision
himself,
that a fake
that person
degree
is trying to
has-
take something and
for
stab someone else.
example,
Within the movie, they've shown
degree has
chants
been
for
presented
payment
by
and
this
all that.
person.
Is it wrong for me to say the
Does
name?
not
You might.
necessarily mean that the court is moving further and saying that you are now non-sagacious or whatever. It's simply saying in this particular matter a false degree was presented. But I don't know of any judgment where they've actually gone ahead and said then as a consequence you're a fraud. So I don't know. So is there a declaration actually coming out of the Constitutional Court also? And can they, without taking any evidence, give such a declaration about a person?
My respectful submission is, my lord, that a constitutional court, now mindful that this 7-member bench left these questions open, but then there are two judgments, said that a court of law for the purposes of 62(1)(f) would be a court which can actually record evidence, which is a plenary court of original, revisional, appellate jurisdiction in civil and criminal proceedings.
But without recording evidence, declaration can be given?
Cannot be given.
Yeah.
And then
And in that case, the declaration will come whether he is, sagacious, righteous or not.
Yeah.
So ये declaration होगा ना, खुद तो जाके नहीं मान सकता
और
declaration.
दूसरा नेगेटिव एज पर
somebody will come challenging.
सिर्फ पैटर्निटी पे हो सकता है शायद, एक एक्सेप्शन है 42 में, देयर इज नो अदर एक्सेप्शन.
Section 42 में तो legal character कोई deny करता है तो suit file होता है ना. If somebody is denying his legal character, then he can file the suit under Section 42 of the Relief Act.
What right?
और अगर आप कॉन्स्टिट्यूशन कोर्ट्स के केसेस भी ले लें ना, तो फॉर एग्जांपल somebody has not, for example election tribunal says that the nomination form एक फलां चीज नहीं है, तो मिस डिक्लेरेशन इन्होंने की है. चलिए ये बात तो हो गई, इन्होंने मिस डिक्लेरेशन की. अब इसका क्या मतलब, फिर हम खुद जोड़ते हैं, हम कहते हैं कि क्योंकि मिस डिक्लेरेशन की है इसलिए फिर आप अमीन नहीं है, इसलिए 62(1)(f) लग. But the court has not said it. The court is not declaring that you are non-sagacious or not Amin. But the court is simply saying you have filed, there has been a misdeclaration in the form. So, उस पर जरा elaborate करें. How do we actually get? Where is the declaration, actual declaration from the court?
तो उसमें कहीं पर वो करेक्शन के भी प्रोविजन है, जो नॉमिनेशन पेपर्स हैं.
और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now, this is again very interesting because the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo motu notice under 184(3) and gives
को warranto देखे ना, वो तो Article 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
But वो तो ऑफिस में जाने के बाद है, not prior to.
जी ऑफिस में जाने के बाद होगा, but the country or oppose the ideology of Pakistan.
Yes. Now, if we read 62(1)(g) on its own with the judgment of Samiullah case, the ban is lifetime ban.
But
If we read them together.
But yeah.
Now read 63(1)(g). It's the same language, ideology of Pakistan. And here it prescribes a ban for 5 years.
Or the sovereignty, integrity, or security of Pakistan.
No, it's the same 62(1)(g) and 63(1)(g) are more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Samiullah Baloch to 62(1)(g), it is lifetime ban. And if we apply 63(1)(g), it is 5-year ban. Unless you say 62(1)(g), Samiullah Baloch is not attracted to 62(1)(g). That could be one argument. So
it's interesting what my lord has observed, because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए, तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक declaration आ जाए, then he's gone.
If he has been convicted and goes to jail, so his sins are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years, and if your guilt has not against you this time, he just convict you.
That's right.
So that would be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yeah,
I would rather
the writing of the court, so I can just go back after 5 years.
So then see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague. And they're overlapping as well, because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens?
Hafiz, alim.
So एक तो वो समझ नहीं आ रही, लेकिन फर्क सिर्फ ये है कि F में तो ये है कि एक डेक्लेरेशन खड़ी हुई है थर्ड पार्टी की, तो जब तक वो खड़ी हुई है वो चलता रहेगा. That's what Samiullah Baloch saying. Samiullah Baloch actually turns on the declaration.
वो हुआ ये कि actually 18th amendment में ये जो declaration by court of law लाने का purpose तो ये था कि वो रिटर्निंग ऑफिसर्स जो है ना वो डिटरमिन ना करते रहे या इस किस्म का एलिगेशन कोई और रैंडमली ना आकर लगा दे, और ताकि ये जो डी, ई और जी के अंदर जो हो सकता है वो एफ में ना हो.
आपके मुताबिक
आखिर मिनट का वो कह सकता है जी, मुझे जैसे माय लॉर्ड ने ऑब्जर्व किया कि मुझे इस्लाम के बारे में नहीं